Good afternoon, everyone. My name is Mehnaz Khan. I'm an attorney here in Fairfax, Virginia. Uh, Main area of my practice is family law. We also deal with some family immigration cases, but we also help clients prepare wills and their state documents. And I wanted to give this brief informative session to the people to just an idea as to what the will is and why do you need a will, as well as what is an advanced directive, medical power of attorney, and a general power of attorney. So I'm going to explain each one of these little by little. Remember, there is any information provided will not be state specific. It will be general information so that every one of us can use it. And if you have any questions regarding your state law or regarding any other country law, then you will have to contact the attorney in that state or in that country. What is a will? Will is a document that you prepare that has list of your wishes as to how do you want your property to be distributed among your loved ones. If you have any kind of assets that has a title to it, means any real estate or any personal property, meaning if you have any house that has a title to it, if you have a car, if you have a bank account, have anything that has a title to it, and you own the title of that property, then you will need a will. Unless that title is joint with someone else. Like if you have a house and that house is joint with your spouse or with your brother or your sister or your child, then it will be transferred to that person at the time of your death. However, you have to make sure that that title has the language of survivorship benefits. Means that if you die, then that property will belong to them automatically. Now, when I talk to belong to automatically, I have many people ask me that question, that what if I die, will all my property automatically be gone to my spouse or to my children or to whomever? The answer is no. There is no such thing as automatic transfer of any properties, unless, as we just discussed, that if the property is jointly titled and with the right of survivorship. If the property is jointly titled with the right of survivorship, then yes, then if one person dies, then the property will be automatically transferred to the other person. And even that, it will not be transferred, but in a real sense, but it will be available for the other person to sell it and transfer to someone else. But when they will be selling or transferring to someone else, they will still have to produce the death certificate of the other joint owner. Another question that I normally get from all my clients is that if I die and if I don't have a will, is the government or the state going to take away all my property? The answer is no. They are not going to take any of your property just like this, just because you didn't have a will. But having a will make it easy on your loved ones. When you die and you have a will and you have an executor of state of that will, then your executive estate is going to take that will, take it to the court in the state, in the county where you were residing at the time of your death, and that court is going to enter an order regarding the powers of that executor of state. And then that person whom you made in your will, your executor of state, is going to use that order, take it to wherever he or she has to take it to your bank or whomever, and get all your assets and divide them according to your wishes in your will. Now, if you don't have a will, then someone will have to start a probate in or some other kind of administrative proceedings in the court, where in the county where you were residing at the time of your death, to have the orders from the court, and that will be a long, expensive, lengthy process. Your loved one will have to spend a lot of money and a lot of time for the court to decide that how your property will be distributed, and the court is going to decide according to the state law at the time of your death. So if you do not want your state to determine who will get your property, then you should have a will, and in your will, you should list all your wishes as to what your wishes are. So that's why having a will is very important. Also, it's not just that you have a will. I always recommend that you have a list of all your assets and debts that you keep with your will, so that your executor of estate it will be helpful for your executive state to figure out, okay, what kind of assets and what kind of debts do you have, so that he can take your will or the court order directly to that bank or directly to where your assets are. Do not keep your will in a safe deposit box or somewhere in a locked closet where nobody can get to it after your death. Please keep it somewhere where your executor of state at least can get to, so that they know what your wishes were and they divide your property according to your wishes. There are certain ways where you can bypass a will. You can bypass a will, as we discussed earlier, by having your property jointly titled. So if it is jointly titled at your death, the other person will have will get that property. If it's not jointly titled, then make sure you have beneficiaries attached to those assets if you can. For example, many bank accounts allow you to have beneficiaries. Many investment accounts allow you to have beneficiaries. Retirement accounts do not allow you to have any joint owner. So in that case, you only can have individual retirement account, 401k, IRAs. They are all individually owned accounts, but almost all of them allow you to have beneficiaries. To make sure that you check your beneficiaries regularly to see if that is still the case, that you still wish for that specific beneficiary to receive that specific share of that asset. Life insurance policies have beneficiaries. Make sure, go back and check that whether your life insurance policies have beneficiaries which are associated to your wishes. If you have a car, either it's jointly titled or you have a beneficiary assigned with DMV in their system for that car. Many states like Virginia allow a deed, a transfer upon death deed, which you can have recorded in the land record of the county where the property is located. If you want to bypass the will, what that deed will do is it is going to simply transfer the property in your beneficiary's name after your death, and you don't have to have a will. But in most cases, almost all of us have keep adding assets to our portfolio. And what if we miss an asset where there is either no beneficiary or there is no jointly title? Then if you have a will, then it will be all catch on for all those assets. Then there is another document that we always recommend that we call Advanced Directive. Advanced Directive is medical power of attorney. Every person above the age of 18 years should have a Advanced Directive medical power of attorney. For example, if you have a college age child, you are paying their bills, they are totally dependent on you, they are your child, but in the eyes of law, they are not child anymore. If they are above the age of 18, you will not be able to make any medical related decisions on their life. So make sure that you have their advanced directive medical power of attorney signed by them, making you an agent so that if something happens to them, God forbid, then you are there to make the decisions, to order their medical records, to make other decisions as to their surgeries and any other thing that you need to make the decisions on their lives. It's very important. It's not just for our old parents, it's for our adult children as well. And then there is another state document that we regularly prepare, which is power of attorney. Power of attorney is uh, works only on finances. Um, uh, Buying or selling. It has to do with money only. It does not have to do with your with medical. Medical related is advanced directive, and anything that has to do with money is general or durable power of attorney. Once you have that power of attorney, you can revoke it whenever you want to revoke it. But if you give a power of attorney to someone, they can sell your property whenever they want to sell it. They do not need a reason for that. So make sure that whomever power of attorney you're giving, you really trust them. So that was general information for will, power of attorney, and advanced directive. If you have specific questions or need more information on these things, or if you want to sit down with me and have a one-on-one conversation, please contact us, and we will be happy to help you. Thank you.